There's only a few scenarios where someone who's hurt on somebody else's property can bring a successful claim under the Premises Liability Act. And it's routinely called slip and fall cases, but there are trip and fall cases, slip and fall cases, injuries because of some other danger on the property. But a lot of times people just call them slip and fall or trip and fall cases. The law that applies in Colorado is the Premises Liability Act, like I said, and it classifies injured claimants into three categories: invitees, licensees, and trespassers. And depending on what you were doing on the property when you suffered your injury, you will fall into one of those three categories. So the first category is invitee. And invitees have the highest protection under the Premises Liability Act because invitees are what's commonly called business guests. And so it's when a commercial business, think of a retail store or a restaurant, invites the public onto their land to transact business, whether that be eat at their restaurant, shop at their store, things of that sort. Licensees, on the other hand, are typically referred to as social guests. So you are not on the property to transact business. You are on the property either in a social setting, or you have permission to be on the property, like walking down a public sidewalk, but you're not actually there to do any sort of shopping or transact any business. Those are what's referred to as licensees under the law. And then the final category are what's known as trespassers, and those are pretty self-explanatory. It means if you're on someone's property and you don't have permission to be there, essentially you're trespassing or breaking the law, you are classified as a trespasser. And I won't spend any more time talking about how trespassers can bring Premises Liability Act claims, because it's almost impossible to do so unless you can show that the landowner purposely tried to injure you if you're trespassing. But let's talk about invitees. So what does an invitee, a business guest, need to show if they're hurt on a business's or a private property that they're there to transact business? Well, first of all, they need to show that there's a danger on the property, that there's a dangerous condition. And that can be any number of things. So think about in a retail store, if there's a water leak inside the store and there's water that's pooling on the floor, somebody's walking by, they slip and they fall and they get injured. The water on the floor is the dangerous condition. But the dangerous condition could be any number of things. There have been cases that we've had where things are falling off shelves because they weren't secured correctly in a retail store. That's the dangerous condition. So you've got to show that there was a dangerous condition. That's usually relatively easy, and I'll talk about in a little bit what should be done if you are injured on somebody else's property. So the dangerous condition is number one. Now here's the key area of the law that provides the main difference between the invitee and the licensee. For invitees, you need to show that the landowner, which is the business owner or the person who owns the land, either knew about the dangerous condition or should have known about the dangerous condition, and that they didn't act in a reasonable manner. And so for invitees, it's an either-or standard. So either they knew there was a dangerous condition there, or by acting with reasonable diligence, reasonable care as a business owner, they should have known that there was a dangerous condition. For licensees, so those again are the social guests, is kind of what they're typically referred to. The standard is there's a dangerous condition, same as with an invitee, but the difference is to prove a claim under the Premises Liability Act, if you're a social guest or a licensee, you need to show that the landowner actually knew about the dangerous condition. So that obviously makes it much more difficult to prove a Premises Liability Act claim, although not impossible, but it makes it a more difficult claim to show that the landowner had actual knowledge of the danger. And so things that we have seen in the past are for private homeowners who know that they have a danger at their house, on their land, in their yard, and they don't do anything about it. Those are examples. Also, if a homeowner knows that it snowed heavily overnight and or there was accumulated ice on the sidewalk, and they knew that and they didn't do anything to remedy that. They didn't snow shovel, they didn't put any ice melt down, and they just left the danger there. That's an example of when you can show actual knowledge. But again, typically, if you're injured on somebody else's property and you're there as a customer or a client for business purposes, you've got the highest protection. So it's whether or not there was a danger that the business owner knew or should have known. So how do you prove should have known? Well, some examples that we've seen are, take for example, restaurants or retail grocery stores. Those businesses have policies and procedures where they need to make sure that they're routinely walking around and doing spot checks and safety inspections on the floors, which typically see, especially in a restaurant, but even in a grocery store, typically see spills. And they're expected to. The standard of care for them is that they will routinely walk around their restaurant or their grocery store or their business to make sure that there's no dangers, that there's no water accumulated, that there's no anything going on with the floor itself or the merchandise, that there's nothing there that is dangerous. And so that's a way to show that, hey, you may not have actually known that there was this danger on the property, but you should have known. And so that's really proven through the type of business that it is. And we typically will have expert witnesses that are experienced in property management, and they will be able to say, like, yeah, the business owner needs to make sure that they're doing XYZ. And if they would have done XYZ, they would have realized that there was this danger on the property. So a couple tips. If you are injured on somebody else's property, whether that be a private individual's or a business's, you want to make sure, obviously, get medical care. If we've had cases where someone slips in a retail store and they have a badly broken ankle and they need to be taken immediately to the hospital. So get medical care. But you want to document the area. You want to make sure that you take photographs, if you can, of the danger, the thing that you either tripped on, injured you, fell on you, slipped on. If at all possible, you want to make sure and take pictures of that, because once you're gone, the store, or the business, or the individual landowner, can remedy that. They can clean it up or take care of it. And if there's no photographic evidence to show what actually the danger was, it makes it much harder to prove your case. Now, this day and age, businesses a lot of the time will have internal surveillance cameras inside the restaurant or the retail store, or even on the outside of the retail store. But unless they are specifically directed by an injury lawyer to preserve all evidence and directed relatively quickly to preserve all evidence, there's a good chance that any video footage that captured the incident might not be preserved. And a lot of times what happens is they say, well, our video surveillance system, it overwrites itself, the footage, every 15 days, every 30 days, and so, sorry, the footage is gone. So then there's really no proof about what happened. So it's very important to document the scene. It's important if you're at a business, restaurant, retail store, something like that, that you want to notify the manager, someone that works there, that you were just injured at the store or at the restaurant, and fill out an incident report form. Or if you do have to go to the hospital or the doctor right away, come back as soon as possible and make sure you let them know and fill out an incident report form about exactly what happened, where it happened, and what happened to you. So that way, again, there's an immediate reporting of the injury and of the dangerous condition that caused the injury. So hopefully this video has explained the law in Colorado about proving a slip and fall or premises liability claim, the different types of or categories of claimants that can proceed under the Premises Liability Act, and then gave you some tips about what to do if, unfortunately, you are injured on someone else's property. If you have any questions, go ahead and put them in the comments, or you can contact Kane Trial Law at 303-919-7777, or see us online at kanetrial.com.